Hi everyone. Just a simple explanation, if you will, of negligence and what that is. I'm going to give you a hypothetical. You start out with somebody that owes you a duty, like a grocery store chain, all right? They owe you a duty because you're a business invitee. You're asked to come in there and shop, grocery shopping. So they have a duty to make sure that you don't slip and fall. They breach that duty. They breach that duty because they have a pallet of bags of ice sitting there for hours and they melt. Then they move the bag of ice, the pallet, and nobody cleans it up. So they have a duty to protect you from hidden defects, and typically you can't see water on the floor in that situation. So they breach that duty. You slip and fall. Causation. It causes you injuries. You break a hip, you twist your knee, and as a result of that, you have damages. In other words, you're out of pocket for lost wages. You have pain and suffering that's compensable by a monetary amount. You have medical expenses. You have an impairment, meaning that if your hip broke and it was fixed, it's not quite perfect like it used to be. Not to mention you're going to have arthritis in the future. Those are future damages. So it's pretty simple. Somebody owes you a duty, they breach that duty, and it's caused you damages. Not everyone owes another person a duty. Sometimes there is just simply an accident. I'm not talking about a car accident because all your fellow drivers out there owe you a duty not to run a red light and crash into you. That's simple. But sometimes there are actually truly accidents where that individual doesn't have a duty. And if they don't have a duty to you and it's not breached, you have no claim against them. This is very simplistic the way I put it, but this would apply to an accident, whether it be a car accident, motorcycle accident, bicycle accident, pedestrian accident, a slip and fall, as I've indicated in my hypothetical, a defective product. When somebody puts a product into the stream of commerce, it's deemed to be safe for you to use in the manner in which it was designed. A vacuum cleaner is designed to vacuum the carpeting. It's not designed to knock rats out of a tree, so you don't put it over your head, and if it falls on your head, you can sue them. That's not the way it works. You've got to use it in the manner in which it was designed. Malpractice situations, whether it be a product within the malpractice, I'm talking about, generically speaking, medical malpractice, you get a knee prosthetic, a fake knee. You have a titanium knee that's put in place of your arthritic knee that's bone on bone, and it turns out that the knee prosthetic is defective. It wasn't cast properly, or it wasn't measured right, or something along those things where you can actually go after the manufacturer of the knee. And then you've got premises liability, and the one that comes in mind is a situation I have where an elderly couple was up north, staying at a hotel, a motel actually, up near the Grand Canyon, and the parking lot was very, very, very dark. The parking lot had holes in the asphalt of which you couldn't see at night. My client stepped into it, didn't see it because it was so dark, fell, and broke numerous bones. That is a premises liability situation. Anytime you're invited onto a business property to purchase something, to stay there, they owe you a duty of safety. They've got to go a little bit overboard to make sure that you don't get hurt there. And that also includes protecting you. In other words, having maybe security cameras or enough lighting so somebody doesn't jump out of the bushes and mug you, or get into your room because they don't have good locks on your doors. They have a duty. They breach the duty by not having sufficient security, and it's caused you damages. So that's negligence in a nutshell, if you will, and that's applicable to any situation where you've been injured. Whether or not you can prove that a duty has been breached, that's another issue. And you never just, and this is something that's hard to get through to a client. They've been in a car accident. The other guy ran a red light. He was doing 100 miles an hour. And the client walked away from it, and they want to sue him. And my question is, why? And they said, because the guy was going 100 miles an hour and he ran a red light. Well, that's fine, and that duty has been breached. But if it didn't cause you any damages, there's no claim there. You don't sue somebody as a matter of principle if you're not going to collect on the back end. On the other hand, you don't get to, let's assume you've had catastrophic injuries. But if you can't prove there's a breach of the duty, you never get to the injuries. Gee, I lost my leg, I lost my arm, I lost both of those things. But if you can't prove that somebody owed you a duty and they breached that duty, you don't ever get to the part about the damages and being compensated. So you can't put the cart before the horse. You have to prove up a duty and a breach before you even get to the damages portion of it. I hope that makes sense. Thank you.
If you have any questions or ideas for these video topics, please email me at lawyer@chuckfranklin.com. That's lawyer@chuckfranklin.com. And I'll consider your topic, and maybe you'll see yourself on my video channel. Thank you.